Namaste, welcome to another MOOC session. Today's MOOC session will be on cultural and educational rights and minority educational institution and related matters in India. So, in today's lecture, we will be covering what are the cultural rights, what are educational rights, what are minority educational institutions in India, what are the various rights and restrictions to be imposed on them. Then we will also see what are the Supreme Court's judgments on the same issue. Then what are the fundamental provisions relating to these that are contained in the Constitution of India. We will also see the debates and controversies relating to this right. And finally, we will conclude our topic. So let us start with a famous observation of Supreme Court of India, in which the Supreme Court of India once said that India has witnessed many invasions, starting from Mughal or Chinese or Portuguese or Britishers. All have come to India and subsequently mingled in India. We have never hesitated to provide them shelter. They have come, they have mingled. Similarly, one poem is there of Rabindranath Tagore, in which he said that India is always open to welcome other communities, creeds, races to our nations. We never send them back. We welcome and we acknowledge their contribution in the nation. So, whenever we talk about cultural and educational rights in India, we know that we have 6 fundamental rights that are ensured by the Constitution of India. One among them is right to cultural and educational right, which is again subsequently supplemented by our educational institution also. So these rights are provided under Article 29 and 30 of the Constitution. Article 29 of the Constitution of India basically secures the right of the minorities in terms of distinct language, distinct culture, distinct script to protect, preserve and spread their culture and language. And Article 30 actually provides for the creation, establishment and running and along with administration of minority educational institutions. Now, when we talk about minority and cultural rights or cultural and educational rights of minorities, then what do you mean by this term? By the term cultural and educational rights, we mean that one person has the right to protect, preserve and promote his particular culture, his particular language, his particular script. As we can see, India is a diverse nation. We have multi-languages, we have multi-cultures, we have multi-religions, but we are staying together. We are a great example of unity in diversity. In India even, we can see that many segments of people or many cultural population are celebrating their culture, are spreading their culture without any hindrance, without any observance. That is because of the constitutional provision enshrined in the Constitution of India under Article 29 and 30. Now the thing is that when we are spreading our culture, when we are promoting our culture, when we are protecting our culture without any hindrance, without any fear, without any restraint, that means this is the right of educational and cultural right, and it is protected by the Constitution of India. Now, when we talk about the minority educational institutions, then we mean that these are some educational institutions, it may be college, it may be school, it may be universities, that are created by minority communities for serving their needs, for making them aware about their particular culture, making them aware about their particular ethnicity, their particular group or their particular you can say religion. Say for example madrasa is there, say for example other Hindu associations are also there. Now the thing is that who will be minority and who is not minority, that means who is majority. In India, the term is not comprehensively defined either in the Constitution or any other specific law. There has been a debate, constant debate regarding the concept minority and the rights and liabilities to be imposed or to be given to minorities subsequently. Now the thing is that although the Constitution of India provides rights to minorities, these are not absolute. This can be curtailed at some point of time by the state if the minority rights or their minorities are not exercising their rights at par with other accepted legal norms, or if they are violating any law, then also they can be prohibited. Now, what are the importance of this right of cultural education? If you see closely the importance of this right, then first of all it comes to our mind that cultural diversity is a must for any nation. If we are culturally diverse or we are staying in a cultural diverse society, then we can exchange our knowledge, we can talk in this regard, and thus we can stay together without any violence, without any sense of enmity, and that will only actually serve our nation's purpose to become a superpower. Our tradition is also protected by this right. Then we can see students can do research in this field, so it is also important for academic purpose. Then we can see it actually it becomes a bridge between majority and minority. Minorities sometimes feel that they are ignored or they are exploited. By this right, they can actually spread their language, their ethnicity, their culture, their language, and by that they can also compete with the other majority people in the country. This right actually is not only provided by the Constitution of India or any other particular constitution of the world, but it is also internationally accepted norm under many international treaties. Now, the most important segment of today's session would be Article 29 and 30 and the debates and judgment associated with them. So, if we closely see the provision of Article 29, then we see that Article 29 actually provides for the rights of minorities, for the creation, for the spreading, or even for the ethnic development of language, culture, or any particular script. But Article 30 provides for the creation, establishment, or administration of minority educational institution. These two articles are related to each other, but the thing is that one is in positive sense, another is in negative sense. In one article, that is Article 29, provides us, yes, you can protect, preserve your right. The word minority is not mentioned in Article 21. But in Article 30, the word minority has been mentioned. Minority educational institution. Article 30 talks about minority educational institutions, but Article 29 does not talk about minority. It says that all segments of citizens having a distinct language, distinct culture, or distinct script shall have the right to preserve, protect, and spread the same. So, here we can see that distinct language, distinct culture, or distinct script means something that is not equivalent to minority. Even who is minority, there is no clarification, but at the same time, when we talk about minorities' right, then we can actually broad the concept of minority, and we can then take this distinct language, distinct culture, and distinct script into the greater ambit of this minority. Because minority term is, minority means what? Lesser in number. It is the term that is used in common parlance. That means lesser in number. So who is lesser in number? In some states, one particular community will be lesser in number. In some states, that particular community will be higher in number. If you divide state-wise, then there will be a different scenario. If you divide nationwide, it will be a different scenario. If you divide region-wise, then again it will be a different scenario. So, Article 29 basically says that anyone who is having distinct language, who is having script, culture of its own, he can spread, protect, preserve the same. But at the same time, in Article 29 subclause 2, it is written that no citizen shall be denied admission into any educational institution which is aided by the state or partially aided. It may be that it is wholly funded by the state, or it is partially funded by the state. In both the case, no person, no Indian citizen can be denied to take admission in the same on the basis of religion, class, caste, or any of the above. Then coming to Article 30, which talks about creation, establishment and administration of minority educational institutions. So now this minority here in Article 30 is used in two sense. One in sense of language and another in sense of religion. So there can be religion specific minority and there can be language specific minority. So the minority communities, whether on the basis of religion or language, can establish, can administer educational institutions of their choice. Whatever they want to do about their culture, about their religion, they can of course do the same. But there are certain provisions. Say for example, compulsory acquisition of any property. There are certain situations when the state feels that one certain property should be acquisition, should be taken from one particular individual for any national interest, then they should give compensation to the person from whom they are acquisitioning the same property. So in case any particular property that belongs to a minority educational institution is needed to be acquisitioned, then the best possible compensation will be given by the state to the concerned authorities, so that the rights provided under Article 30 is not jeopardized, so that they can go somewhere else and they can create, establish, promote their educational institution. Article 30 clause 2, that talks about the state shall not discriminate between educational institutions in terms of granting aid on the basis of religion, race, class or language or any of the same. That means if state is giving aid to particular institution, then state should give financial aid to each of the institutions of same nature, but it should not do the activity that we are going to give a particular minority institution fund and we are not going to give fund to any other institution. It cannot be this case. If this happens, then the state will be violating Article 30 clause 2. Now we will see some Supreme Court and High Court judgments which directly relate to the application of Article 29 and 30 inasmuch as they relate to cultural and educational rights in India. So the first case in this regard would be State of West Bengal versus Anwar Ali Sarkar. It is a case of 1952. In this case, the Supreme Court of India held that although there is one article, Article 14, that speaks about right to equality, but right to equality does not mean that the state cannot give a special favor to the minorities, because minorities have the right or get the protection under Article 29 and 30. So if minorities in regards to their educational institution, their culture, their script and language, they get some privilege or they get some extra benefit, then this is protected under Article 29 and 30. So there is no question of violating Article 14. Then the next case will be Kerala Educational Bill 1957. In this case, the Supreme Court again held that it is the choice of some particular community to establish or not to establish any educational institution. If they establish, then it is completely of their choice and there cannot be any question regarding this. Then another case, TMF Pai Foundation versus State of Karnataka. In this case, it was said that Article 29(1) is not only limited to minority communities but also to other segment of citizens who are having a distinct language, who are having a distinct culture, who are having a distinct script. So as I already said earlier, that this Article 29 indirectly relates to minority, because if anyone has distinct language, if anyone has distinct culture, if anyone has distinct script, then it means that it is not so popular, it is distinct, it is specified. So in that scenario he becomes minority, but in general anyone who has a specific distinct language, culture and script may claim right under the same provision. Then there is another provision, PA Inamdar versus State of Maharashtra. That is again very important case. In this case, it was held that the educational institutions which are running by minority communities can determine the fees and curriculum of one particular educational institution in which they are administering, but the thing is that they cannot exceed or they cannot cross the limits set by any particular law. In simple words, they cannot violate any particular law. If they are violating any particular law, then their right will be jeopardized. They cannot again claim this right. Then another case is there, St. Stephen's College versus University of Delhi. In this case, it was held that the right of minority educational institution will have the opportunity to admit students of their choice subject to limits of reasonable regulations by the state. That means if they are under UGC, so they cannot violate UGC norms. If they are affiliated to any particular university, they cannot violate the essential norms of the particular university. So laws should be prevailed. Laws cannot be violated. Otherwise, they have the right to give admission to any person. They have the right to decide the fees. Even in some cases, the state can also impose fees, minimum fees, and exceeding the same will be termed as capitation fees or excessive fees. In that case, state can also come forward and it can say that no, you cannot charge that much fees because it is excessive. In COVID time, we can see that state from time to time advised that minimum fees should be charged. Even Supreme Court came forward and it also said that minimum charges should be taken from the parents. Then another case is there. It is Islamic Academy of Education versus State of Karnataka. In this case, it was held that it actually relates to reservation policy. That association claimed that they are not duty bound to provide reservation policy, and they are also going to give some special reservation to their particular community. Then it was held by the Honorable Court that yes, you can give reservation to a particular community, that's perfectly fine, but at the same time you cannot compromise with the legal provision of the state. Now here this reservation policy is a debatable issue. From court to court it varies, from state to state it varies. Some states are saying, in some state minority educational institutions are giving reservation policy, in some states are not giving reservation policy. But we need one comprehensive policy which should be followed by all the minority educational institution. Now suppose one minority educational institution is getting aid, either a complete aid or partial aid from the state. That means state, from where state will get money? State will get money from our taxes. We are paying tax, they are getting the money. Now if any minority educational institution or any educational institution in bigger scenario is getting fund from the state fund, from the state treasury, and if they are not allowing other communities to come, other communities to participate in their educational institution, then in some way this is violating the rights of other persons also. So moving forward to next case, this is very important case, and that relates to the minority status of Aligarh Muslim University, AMU. So in 1981, one case was filed before Allahabad High Court regarding the minority status of Aligarh Muslim University, and Allahabad High Court said that yes, it is minority in nature because it was established by some minority persons, and it is run by some minorities, so it is minority institution, and here minority persons can be given preference, can be given some positive benefits in comparison to others. But the central government was not satisfied with this judgment, and in 2006 the then UPA government approached the Supreme Court that we are not convinced with the judgment of Allahabad High Court. And in the year 2016, one judgment came from Supreme Court that yes, the judgment of Allahabad High Court was not correct, and the name of the case was Aziz Basha versus Union of India. But again, this judgment was challenged before the Supreme Court itself. So Aziz Basha versus Union of India overruled the judgment of the Allahabad High Court, and in Aziz Basha case, 5 constitutional judgments was there, but again it was challenged. Now the central government has filed one affidavit that yes, we support the judgment. We also think that this Aligarh Muslim University is not a minority institution because it is funded by the central government. It was created under one legislative enactment. So how can it be minority institution? It is completely funded by the central government. It's a central university, and the term Aligarh Muslim University, you cannot give special preference. Now the case is pending. 5 judgments have decided that it is not a minority institution. Now what will the larger bench will decide? That is a matter of time. We'll see what the larger bench decides. So then another case is Pramati Educational and Cultural Trust versus Union of India. That relates to Article 29(1). It says that Article 29(1) also gives the right to the institutions that are made to promote, protect our culture, distinct culture of course, or script or language, that they can affiliate their institution with any other institutions of their choice. So suppose in Tamil Nadu, one particular institution is there which is a minority in that particular state, but it is not minority in other state. So if it is creating any particular institution there, it can affiliate its institutions with other institutions of other states where it is not minority. For example, so I was giving example of Tamil Nadu institution. For example, some Marathi people are staying in Tamil Nadu. They have created one particular institution, but they are not minority in Maharashtra. And in Maharashtra, they have some certain institution. So that Tamil Nadu Association of Marathis can affiliate themselves with Marathi institutions. There cannot be anywhere in this regard. So this was held in the present case. Then moving forward to another case, it is very important case, Saint Xavier's College versus State of Gujarat. So in this case, again it was held that the state cannot interfere with the internal procedures of minority educational institutions, but they can control in the matters of national importance. Suppose one particular thing is taught in any particular minority education institution. State is not duty bound. Actually, it is neither duty bound nor it is nor it has any right to interfere with the internal procedure. What it is going to be taught there. But the thing is that when that particular institution does anything which is harmful for the national security, or which is harmful for the national importance, or something should be imbibed there in regards to quality, in regards to any other matters, then state can interfere. There were certain issues relating to certain educational institutions. It was said that these institutions are actually propagating certain agenda. In this regard, if evidence is there, if proof is there, of course state can go there and state can intervene. But if nothing as such is there, then state cannot go there. And then another important case is there. It's a very famous case, and this case is SP Mittal versus Union of India. So it relates to Auroville. Auroville, it was actually created by Aurobindo Ghosh. So he made one particular place. He gave the name of Auroville, and in that place he used to preach to his devotees that a particular philosophy of life. He used to teach how to live a life, particular life, how to proceed in life, and after his demise, other persons got the possession of the same, and they later on claimed that it is a minority educational institution and it should get all the protections of Article 29 and 30. But here the court said that for claiming to be a minority institution, one should remember that it should be created by them for the upliftment of their culture. In this present case, it was neither a place of worship, it was a place of spreading the philosophy of life. So it was neither a place of worship nor it was created by them who are claiming. So they did not even make it. So it was created by someone else, Aurobindo Ghosh. So it cannot be claimed to be a minority institution. Rather, it's a philosophical place. Here, philosophy will be taught. It is not a religious or a linguistic place. Also, it is above this. The court said. Then, coming forward to some debates and issues relating to the cultural and educational rights versus other claims, because in India or in any other particular given society, we can see that there are many segments of people. If there are many segments of people, and if you talk about freedom of speech and expression, even one will criticize other on the basis of merit. If on the basis of merit one is criticizing other, there is no issue, and this sound criticism will actually help to rise forward or go forward. So one segment of people is saying that yes, minority and educational rights is very much needed, but another is saying that in the name of cultural and educational rights, sometimes the states are giving unfair advantage to certain segment of people, be it in the name of vote politics or in the name of any other appeasement politics. So there are two sides. But the thing is that yes, minority and educational institutions are needed in any society, especially in democratic society. But there are the debates. What are these debates? What are the key points in this regard? The first is protection of minority educational institutions. Who will be protecting the minority educational institution? Whether the state will be protecting or the management community will be protecting. And if there is any issue regarding the education quality and all this, who is to be blamed? This is the first debate. Then funding of minority institution. Who will be funding this minority institution? Whether government will fund, whether state will fund. If government and state is funding, then from where they will get money? From the treasury, when the majority are saying that we are also paying taxes. Why government or state is using our taxes to other persons? This is again a debate. So then another debate is reservation in minority institutions. Whether reservation is to be given in minority institutions, whether minority institutions should not give reservations because they are specifically made for one particular purpose. Now, in this aspect also, if they get government aid, if they get state aid, then should they give reservation? And in another scenario, if they are not getting any aid from the government, then they should give any reservation. So scenarios are different. Then another is language and curriculum. So what should be the mode of instruction of a particular minority educational institution? If in that particular language he is taught, whether there is any scope of scope in future, whether he can or she can develop he or his personality in terms of other global measures. Or then is another provision, admissions. who will get admission, what criteria should be fixed for admission. These things are also debatable issues. Then management, who will manage this issue? Whether government person should also be there, or whether only the persons who are having sound knowledge in that particular minority institution should get managerial rank, or someone else should be getting. Because sometimes between or among that particular language, linguistic group, that particular religious group, that particular cultural group, that particular script group, there is some enmity between persons, and they go to the court, and then court is to decide who is going to get managerial post, who will be the authority in this regard. So there is again issue in this regard. Then of course quality of education. There is a great debate as to quality of education. Recently you might be knowing that in some states, for example particularly in Assam, minority education institutions in the name of madrasa have been discouraged. Thus then the CM Dr. Himanta Biswa Sharma is saying that what they will do by studying in minority education institution. The same contention is laid down in Uttar Pradesh. But the thing is that the other people who are in other part, they are claiming that no, this contention is not right. But Mr. Sharma is saying that no, we want to make our children doctor, engineer. If they study in madrasa, what they will become? They cannot do anything for the nation, or somehow they will be unemployed, and again it will be the liability of the state to manage them. So we want to protect them, we want to actually make them something in future. So we are discouraging this trend. Now let us see what happens in future. For now it is a debate from both the side. Comments are coming. In conclusion, we can of course say that these cultural and educational rights are fundamental rights that are guaranteed by the Constitution of India, that is again available through many international instruments, treaties. But in India, it is a different kind of right, because in India we witness a multilinguistic, multicultural, multi-religious country where diverse opinions, diverse perspectives and diverse ideas are always there. It has been there from time immemorial. So the state governments and the central governments are doing their part to ensure the rights and duties of all segment of people, including the minority communities. And we can see that there is National Commission for Minorities, there is National Commission for SC/STs, there is National Commission for OBCs, there is National Commission for other women, even there is National Commission for many other segment of community. Even the states are also creating a state commission of linguistic minorities, state commission for religious minority and others, and civil societies are also working in the same regard. So let us hope for the best, and we think that the rights of these minorities will be protected, and it will not be misutilized also. So it should come from both way, and thus India will again reach the upper echelons of the Global Committee of Nations, as it was at some point of time. So with this, and with the hope that you have enjoyed this session, I wind up. Thank you so much. Jai Hind.